Excuse me. Good morning, everyone. Welcome back to the ESA webinar series powered by our good friends over at Site. Before we get started today, just some housekeeping as always. Reminder that the presentation and recordings of this webinar and all webinars will be available later today at www.esa.org/webinars. And a reminder that virtual Envirotech is June 11th and 12th. There's 27 presentations over 2 days via 7 webinars. And we've kept registration low at $49 for members and $79 for non-members. It's about 14 hours of professional development hours if you need the hours. You don't have to attend all of it. You can check back later. The recordings will be available for those that are registered. So check it out. We also announced a new webinar this morning, one more to end our series at the end of June with Brian Keating again, and some Alberta stories about Alberta birds, some interesting facts and educational stuff. It's good for your family and kids, so I encourage you to do that. It'll feature my photography. So I encourage you to sign up for that one, and we'll be announcing one more about protocols for having staff coming back to work with an HR consultant and helping you get your businesses back up and running. We'll be announcing that probably tomorrow. So for today's webinar, sponsored by our good friends over at Trace Associates, we have Jacqueline Stevens and Anand Srivastava with Wilms and Shires Environmental Lawyers out of Ontario, and they'll be speaking to us on managing environmental risk and liabilities, the legal perspective. And when we're done, we'll do the usual question and answer. So I'm going to turn it over to Jacqueline and Anand, and we'll let them get started. You should have control, Jacqueline.
Okay, there we go. Perfect. Good afternoon, everyone, or good morning, I guess it is, out in Alberta. Thanks for attending this webinar. I'm here with my colleague, Anand Srivastava. We're both lawyers with Wilms and Shire Environmental Lawyers. And today we're going to chat with you a little bit about managing environmental risks and liabilities from a legal perspective. And also we'll speak briefly about some of the COVID-19 specific issues and new regulations or orders and directives that have come into place. And as always, we legal types have to provide a disclaimer that our presentation is not legal advice and does not create a solicitor-client relationship. If you find yourself in a situation that looks or feels like what it is we're speaking about, you should get in touch with a lawyer, as all situations are fact specific. So now that that's done, let's move on to the presentation itself. And Joe, just as I said, I can't move the slides.
Click.
Click.
Page down,
Page down. I'm hitting page down. What if I move it to a different? Well, this is not good. Nope. Sorry, everyone. We didn't.
We'll get this fixed.
Anand, what if I give the keyboard to you? See if that works. Sorry, everyone, for this technical glitch. Are you able to make the move?
Do you want me to make him presenter then?
Yeah, perhaps, Joe.
How does that look, Jackie?
It looks okay. Can you scroll down?
Yep.
Okay, perfect. So sorry about that, everyone. We'll get back on track.
Back on.
Okay, we can move to the next one, Anand. So here's just a quick overview. We'll cover off some basics about environmental risks and liabilities. We'll move on to civil liability, regulatory liability, and then finish off with some ideas and checklists about managing your environmental liabilities. So when you're starting to think about risks and liabilities, some questions that you might ponder are, what is the environmental condition of the property? Do you have an environmental management system? What is that? Do you have spills prevention or contingency plans? Does your operation have the necessary approvals it needs? What emissions do you have? Have you had a spill or a leak? Do you have you been doing some environmental investigation work? And you have exceedances of regulatory standards? Or is there contamination that may be impacting an off-site property? These are all of questions that you start to think about when you're assessing environmental risks and liabilities. So as a starting point, we talk mostly about two types of liability. We talk about regulatory liability and civil liability. And regulatory liability kind of comes in two flavors. We have orders and approvals, and they make you do something or allow you to do something or perhaps stop you from doing something. And then we have prosecutions. And these are usually where charges are laid for failure to comply with environmental laws or regulations. And then on the civil side, this usually means lawsuits between parties. For example, one party has a contaminated property where the contamination has migrated from a neighbor, and they decide to sue the neighbor who's the polluting property owner. Generally, in lawsuits, you're looking for damages, some sort of monetary payment for either the cost to clean up or the cost for the diminution in value your property has suffered. You may also seek some declaratory reliefs, and Anand will speak a little more to those in a few minutes. We also need to be concerned because environmental liability is not just something that companies can be saddled with. There is personal environmental liability that individuals need to be concerned about, because individuals may be ordered and or prosecuted for failing to comply or for taking steps. And there are statutory liability provisions that speak to obligations of directors and officers. So even as a director and officer, you might think that you are insulated from environmental liability, but that's not actually the case. We also see environmental liability rarely, but occasionally in civil lawsuits, and that's where individuals are sued in their capacity as either director and officer or someone who had management and control. And there is a fairly recent case called Midwest in Ontario, and we'll talk about it in detail a little bit further down, but essentially the court pierced the corporate veil to get to the individual director and officer of the corporation. So these are additional concerns for individuals where you are operating in either as a director and officer or someone in environmental management and control of an operation that you need to be aware that you may face personal liability. So Anand's going to take us through some of the civil liability aspects.
Thanks, Jackie. And that's right. Jackie's given us an overview of the differences between regulatory liability and civil liability at 30,000 feet. And I'll try to bring it down to about 5,000 feet. Obviously, Jackie's absolutely right that every circumstance is fact specific, but civil liability deals with private disputes. That's not to say that a particular regulator might not be involved, but they might be involved in their capacity as a landowner or somebody alleging regulatory negligence. But most of these civil disputes are between private property owners or perhaps between a landlord and a tenant. There could be individuals involved. There could be class actions involved, although the environmental class action litigation atmosphere is pretty subdued in Canada as compared to, for example, south of the 49th parallel. And at a high level, somebody who is perceived to be aggrieved, they are the plaintiff. They are going to bring a claim, and they must prove both liability and corresponding damages to succeed in any lawsuit. And for those on the webinar, you might think of this in your own capacity, but I'm sure there are a lot of environmental professionals on this call as well, and you might be thinking about this through the lens of what your clients are thinking about and the circumstances that they may be in, whether it's perhaps that they are aggrieved or that somebody is making claims against them. Those claims must be pled in what are known as causes of action, and we've listed a handful under the second bullet: nuisance, negligence, strict liability, trespass, breach of contract. Those are the types of things that a plaintiff may allege that a defendant has done. In Ontario, there's a statutory cause of action that we don't see in a PIA, and plaintiffs also see and ask for injunctive relief. That is, asking the court to order that something actually be done as opposed to a payment of monetary damages. And you'll see in the last point we talk about courts could order such an injunction, and the most likely relief, should you get there, are damages. And that's a check, that's a dollar figure, and it should be compensatory for the harm that the plaintiff has suffered. But we have to be aware that there are, in rare cases, punitive damages awarded, and Jackie nicely outlined, exposures to personal liability. It's important to be aware of this concept of limitation periods for those who aren't familiar with them. A limitation period balances a plaintiff's right to seek compensation with the principles of finality. I'm going to put it to you that it might be unfair if a plaintiff were to discover that he or she had a claim and then sit on it for 10 years or 20 years. That might be inherently unfair. And so we have limitation periods that, by and large, in Canada and certainly in Alberta and Ontario, start a 2-year discovery trigger date. That is, after I know about a claim that I might have, I have 2 years to bring my claim. In addition to that, many provinces, like Alberta, have ultimate limitation periods that say, notwithstanding the fact that you may have only recently discovered a claim, there's an ultimate limitation period after which it doesn't matter when you discover it, you can't bring your claim. And in Alberta, that's 10 years. So most people on the line might be thinking, well, how does that kind of accord with historic contamination? What happens if the contamination and the source of that contamination is more than 10 years old? And the way that we address that is EPA section 218, and there's an exception to the 10-year limitation period, the ultimate 10-year limitation period, that in certain circumstances, a plaintiff can ask the court to waive the ultimate 10-year limitation period. And the applicable law is set out actually in a recent case from last year called Brookfield and Imperial Oil. And the court talks about balancing a plaintiff's right to act with diligence and bring forward a claim with a prejudice to a defendant. And, in this case, we had a claim that related to activity by Imperial Oil as far back as 1949. And in fact, Imperial Oil at this property pursued and received a remediation certificate way back in the old legislative regimes. And the question was, is Imperial Oil still responsible today to answer to this plaintiff's claim? And the short answer was no, Imperial Oil was not responsible. Every case is different, but the plaintiff has to ask the court before trial if it can bring its claim if the subject of the contamination is greater than 10 years old. I'll quickly comment on how COVID-19 is affecting limitation periods. At a high level, we're seeing jurisdictions across our country pause some limitation periods. Governments understand that these are trying times and it might not be the time to bring a lawsuit. And so, for example, you'll see on your screen that the federal court has issued practice directions that suspend the running of the limitation period backdated to March 16th, 2020. And similarly in Alberta, for anybody who's interested, you could look up Ministerial Order 27, 2020. But the long and the short of it is that certain limitation periods are suspended, including the 2-year discovery and the 10-year ultimate limitation period that I was talking to you about. And that suspension came into force and retroactive to March 17th of this year, and it currently has a sunset date of June 1st. We'll see what happens in the coming week. But interestingly, the suspension of limitation periods does not apply to IPIA, nor does it apply to the Provincial Offences Procedure Act. And so as Jackie and I think about how that might impact practice in Alberta, we certainly think about prosecutions, and we're going to get to prosecutions a little bit later in our speech. But just as civil parties have limitation periods that govern when they might start a claim, so too does the regulator in certain circumstances. And Alberta Environment and Parks, for example, has a limitation period that's prescribed in IPIA to commence a prosecution. And it appears to us that that limitation period, for example, is not paused by these ministerial orders. And again, at a high level, Ontario has a very similar emergency order in place. It backdates to March 16th. And in this case, there's no actual end date just yet. But again, same type of framework where we see most limitation periods suspended, but there are certain exceptions. Jackie, back to you.
So I'm going to round off our discussion about civil liability with just a comment on a couple of those causes of action that On had mentioned earlier. One of them was nuisance, and nuisance is the unreasonable interference with the use and enjoyment of land. And for some, that might be the local pig farm. For others, it might be the bakery. Somebody else might not like the whirling of a fan in a manufacturing facility. But this particular case that's on the screen, TMS Lighting and KJS Transport, was all about dust. KJS is a transport company. They had a gravel driveway. There was dust. And TMS is lighting is a retail lighting manufacturer where dust doesn't really mix well in terms of them manufacturing their high-end light fixtures. This case is important to us because it affirms what was put forward in another earlier case called Antrim about the factors that the court has to consider when they're looking at whether a nuisance has occurred. And those factors are the severity of the interference, the character of the neighborhood, the utility of the defendant's conduct, and the sensitivity of the plaintiff. So those are the factors that are related to a nuisance and whether something that's happening could be considered a nuisance. The second case is the Midwest case that I mentioned earlier about having pierced the corporate veil. And in this case, it reaffirmed that statutory private right of action that we mentioned that exists in the Ontario Environmental Protection Act, but it also confirmed the negligence tests and the nuisance claims based on TMS and Antrim as part of the body of the liability findings. What's interesting about this case, though, is the damages that are awarded and who had to pay. So the court found that Mr. Thordarson, so the defendants were Thorco, the company, and Mr. Thordarson, the director, officer, chief bottle washer, doer of all things. So the court said, well, Mr. Thordarson, you can't hide behind a corporate veil in this situation because you were the individual, the controlling mind of this company and making all decisions as they relate to the company. So the court wasn't interested in letting Mr. Thordarson off the hook, and they found liability against both he and his company and awarded $1.328 million for restoration costs. The other piece is that they awarded punitive damages, and we rarely see punitive damages in the civil environmental context. And the court basically said that the reason they were awarding it to both Thorco and Mr. Thordarson was because of their wanton disregard for its environmental obligations. And part of that related to completely ignoring environmental orders that were in place, not taking the steps that they were required to do prior to the lawsuit having even been commenced. And the court didn't look very kindly on that. And in awarding punitive damages, they were punishing the defendants additionally on top of what the actual costs were to do the remediation. So we next want to move to regulatory liability, and we're going to start first. I'll give a few updates about some specific things we're seeing in relation to COVID. It's not an exhaustive list by any means in terms of jurisdiction or even the number of different orders that are out there or decisions that are out there, but it's a sampling of some of the key aspects of how public health risk is being addressed in this sort of these COVID times as it relates to environmental obligations. So from the federal perspective, we've basically heard from Environment and Climate Change Canada. Well, actually, we haven't heard anything really. All of their laws remain in effect as far as we're aware. There have been some reporting obligation extensions under the Greenhouse Gas Reporting Program, under the National Pollutant Release Inventory, but generally speaking, it's business as usual. They're still proceeding with, the permitting is still happening under the Species at Risk Act, and on it if you want to advance one. And we know from the Department of Fisheries and Oceans that they've confirmed that all critical functions continue to operate, including licensing, catch certifications, monitoring, and enforcement. So if you're regulated federally in any way, it seems that those environmental obligations are status quo. If you are impacted by anything relating to COVID, there certainly is an opportunity to make note of that. Give your provincial or your federal officer a call if you know him or her and talk to them about it. But generally speaking, you're required to comply. So now we've moved to Alberta. There's been a number of ministerial orders put forward. And at the end of March, beginning of April, most of them talked about relief from reporting. So we had relief in Ministerial Order 15 from reporting under the Technology Innovation and Emission Reduction Reg. MO 16 was dealing with renewable fuel standards regulation. Their reporting obligations were extended. The following one, MO 17, suspended reporting requirements for approvals and licenses under APIA, the Water Act, and Public Lands Act. And Ministerial Order 219, suspended reporting under the Coal Conservation Act, the Oil and Gas Conservation Act, and Oil Sands Conservation Act. And that was reporting for annual reports, exploration reports, and a number of others. So that was what we were seeing. And then middle of last week, we saw a different version of suspension. And we see two decisions, 2020-05-20A and 2020-05-20B, coming from Alberta Energy Regulator, where the title of these two decisions is Unilateral Amendment to Approval Conditions. And they're specific to two separate groups of operators. There's those operators who operate under the Oil and Gas Conservation Act, and there's those operators who are in situ oil sands project operators in a specified appendix list to that decision, all who operate under approvals under APIA, Water Act, and the Public Lands Act. And essentially, this is suspended monitoring requirements. So we've moved from just saying you can have a little extra time to report to now AER in relation to these two groups of operators saying you don't have to monitor. And the monitoring lists are fairly extensive that show what is temporarily suspended. I just noted a few on the slide. One interesting piece is that groundwater monitoring under both under APIA approvals has been suspended unless the monitoring is necessary for protection of human health and ecological receptors. And it only goes, I think, till September 30th. And there's a requirement for 1 monitoring event. So there's a couple of extra terms around that groundwater piece. But all of the other monitoring activities listed are suspended without a further date at this point. So we have things like fugitive emissions program monitoring done by third parties, lab testing of water releases, other auditings, wildlife monitoring. So if you are an entity or your client is an entity that falls under either of these groups of operators, you need to have a careful look at what the directives are indicating for monitoring suspensions. Just as a brief comparison, in Ontario, same thing for the Ministry of Environment, Conservation and Parks. Even with the emergency order that Ann had mentioned in terms of limitation periods, the Ministry of the Environment has said, no, we are full speed ahead, but call us. We're working through particular individual situations as best we can, and there may be individual relief. And if you can't comply, you certainly need to be making some notation of why. But the Ministry of Natural Resource and Forestry, at least in regards to their aggregate resource portfolio, has said, no, actually that emergency order has suspended regulated timelines under the ARA. So we have 2 ministries in Ontario who are not sort of on par with each other. They're dealing with the emergency order a little bit differently. Ann, back to you to talk a little bit about regulatory orders and approvals.
Thanks, Jackie. And we've certainly now touched on it a little bit, especially in the approvals context. But these are 2 of the, I'm going to say, tools in the regulator's toolkit to either require or assist with compliance given the applicable law. And Jackie and I are going to look at it from the perspective of orders and what happens when an order is issued, and how might that change you or your client's approach. And what you should be seeing on your screen is a flow chart we've put together that looks at the deadline process to appeal regulatory orders and approvals. And you'll see that whether it's a case of an EPO or if it's an approval, amendment, refusal, cancellation, or suspension, there's a very short time window that you must give notice of your intention to appeal to the Environmental Appeals Board, the EAB. And it can be as short as 7 days. And so you and your clients should be acutely aware of the timing to make sure that you don't miss this limitation period outside of the civil liability context, but within the regulatory liability context. And you'll see that the flowchart continues to, a hearing with the EAB, and the EAB then issues a report to the minister with its recommendation. And from there, it's the minister's choice as to what he or she may do. And we highlight that. And again, just as an interesting compare and contrast, this is the flowchart for Ontario. And while the terms are slightly different, and instead of the Environmental Appeals Board, we have the Environmental Review Tribunal, what's interesting here is that there is no recommendation to Ontario's Minister of Environment, Conservation and Parks, but rather it's the tribunal who makes the decision. And in Ontario, there's a right of appeal from what the tribunal says. In Alberta, there is no inherent right of appeal from the minister's decision based on the recommendation of the board. So just a bit of a nuance. These are on your screen a list of 7 orders that have been the subject of extensive litigation, and I'm certainly not proposing to walk everybody through all of the orders, but let's talk about some of the key points that we can pull from these recent orders to give you a sense of how environmental liability may arise and the trends we see with these orders. The first on your screen is Kawartha Lakes, and here in Ontario, it was made very clear through that extensive litigation that bounced around between the Environmental Review Tribunal, Ontario's Divisional Court, and even as high as Ontario's Court of Appeal, that fairness is not relevant or necessary in an order. The regulator has its purpose as set out in the applicable statutes or regulations, and the regulator is permitted to fulfill its purpose. And of course, the subject of that litigation was the city of Kawartha Lakes, which was, for all intents and purposes, not the polluter and was a flow-through property. There was a fuel oil leak from a residential home that flowed through the city of Kawartha Lakes property and into a water body. Baker is another example where we have the former North Star Aerospace Corporation going bankrupt, and the ministry in Ontario issuing a personal order to a number of former directors and officers, among others. And these directors and officers were ordered on the basis of their former charge, management, and control over the corporation at the time that the contaminating activities occurred. And these individuals appealed, and they fought for a long time and ultimately settled for a large payment from these individuals to satisfy the ministry that the appropriate work was being done. Roca, McQuiston, and Rubin all talk about the expanding scope beyond just corporations, municipalities, and their directors and officers. In Roca, an individual was an advisor to the company. He had a personal financial interest, but he didn't own the company, nor was he a corporate director and officer, and an order was upheld against him. In McQuiston, we had a number of individuals and entities being ordered, as far as an accountant who had a power of sale over a particular piece of contaminated property, the real estate brokerage that had the keys to the lockbox, which in turn the real estate brokerage was trying to sell the property. Those were the among the people listed on the order. And again, Rubin, we had a defunct company, and we had the second generation of the sons of the dad who operated the company being ordered. Perhaps of more interest to the folks on the line today are the Sears and Domtar orders, which have received a lot of press in Alberta. And Sears was interesting from the perspective of the EAB confirming who may or may not be a person responsible, as that term is used in EPEA. And we had Sears and Suncor upheld in February of this year as being persons responsible for continuing with off-site delineation and remediation. And we had Concord, a successive owner, an entity that purchased the property recently, 2015, that was determined not to be a person responsible. And Domtar, the same concept applies, where we have this historic wood processing facility, and unfortunately a large contaminant plume arising from there, and that litigation spans into orders that were issued previously, and then as recently as last year, new orders were issued within the Environmental Appeals Board process. The one case that I think deserves a quick mention beyond the list that I'd imagine many are familiar with, given that it was decided by the Supreme Court of Canada last year, is Redwater and the Orphan Wells Association. And here we have this interplay between a regulatory order, which was quite clear, it's an abandonment order relating to disclaimed wells, and the bankruptcy legislative framework. At a high level, when an individual or a corporation goes bankrupt, they enter creditor protection, and they get to try to come out of bankruptcy at the other end, and dealing with all of their creditors. And the question was, is AER a creditor of a bankrupt? In this case, it was a junior exploration company, and their receiver was Grant Thornton, or does the regulatory order apply or take precedence? And I won't walk you through all of the court decisions. It hit 3 levels of Alberta. Well, first Alberta Court of Queen's Bench, Court of Appeal, and then finally the Supreme Court of Canada. But the long and the short of it is that AER's order was not subject to the bankruptcy proceedings. So to put it in a different way, AER was not a creditor of the exploration company, but instead, now its receiver, Grant Thornton, had an obligation to continue to comply with the provincial environmental regime and respond to the orders. It was not a claim that is provable in bankruptcy. And it's an interesting outcome as people, especially in today's times, worry about bankruptcies and how that may impact environmental regulators' decisions. Jackie, back to you.
So some of you may have seen Sean Parker's presentation. Sean's from McLennan Ross, and he did a presentation earlier in this ESA series about inspections and investigations. So I'm going to now talk about what happens after that, once the investigation is complete and the regulating body decides to prosecute. So we have, from this perspective, a little bit of a checklist of, so who can prosecute? Well, the federal, provincial, or municipal governments, and sometimes even individuals. We do have something called a private prosecution. Doesn't get used very often, and we're not going to focus on that, but it gives you an idea of who can actually prosecute. And against whom can they prosecute? Well, we've heard about personal liability, so individuals, partnerships, corporations, directors and officers who have management and control. Even regulators and cities, municipalities can be prosecuted. So it's pretty broad who can end up getting charged, if you like, with an offense. And why do people get prosecuted? Why do companies get prosecuted? Well, usually it's for contravening environmental laws, regulations, permits, approvals, orders, failing to report a spill, or some other misstep as relates to environmental laws that we're required to follow. And the sanctions most often are fines, court orders, sometimes imprisonment, sometimes paying back the profits that were earned, and oftentimes a victim fine surcharge. You can skip ahead one more.
Sorry, Jackie.
That's all right. So when you're being prosecuted, you are the defendant, and there are defenses that may be available to assist in responding to the charges that have been laid against you or the corporation. And some of those defenses, you know, a technical one, but a big one, is that when you get to trial, the Crown can't prove all of the elements of the offense. And if they can't prove the elements of the offense, then you can't be found guilty of them. Maybe you actually complied with the order and that's your defense. Maybe there was an act of God. We'll see how pandemics work in that in the probably near future, but I can't say pandemics sit in the act of God category just yet. Maybe there was officially induced error where a government entity gave you advice, you did something, and then after the fact you learned that the advice you had received was incorrect. Maybe there was necessity. Maybe the harm related to what happened was less than the harm had you not let the event go. And the biggest one we see, and the one we'll spend the most time on today, is about due diligence. So due diligence has two branches. One is about taking all reasonable care to avoid the offense that happened. You don't have to have superhuman efforts. You just have to have a high standard of awareness, and that you've been taking steps are incorporated into your culture, and you take prompt and continuing action. That could be a full defense to a charge or prosecution. There's also the second branch, which is really about the reasonable belief in a mistaken set of facts, that if the facts were actually true, then it would have rendered the act or omission innocent. The next slide lays out some of the key elements of a due diligence defense. Did you have an environmental management system in place? Was it implemented? Were you complying with industry standards? Perhaps there was no feasible alternative to prevent the contravention. The activity that was conducted was done so by competently trained professionals, and they were properly supervised. Or perhaps there was just a coincidence in time between the failure to exercise the due diligence and the alleged unlawful act. We have two cases that Anand's just going to briefly touch on to illustrate some aspects of that due diligence defense.
Thanks, Jackie. And yeah, these cases play off of each other rather well. The first is a defendant by the name Zelstroff. And in this case, there was wastewater effluent that was discharged into the Columbia River. And the defendant was found guilty. And the defendant pled a due diligence defense and said, well, no, look, we had all of these procedures in place. We did the absolute best that we could. To borrow the language that Jackie just reviewed from other case law, we took all reasonable steps. And the court disagreed. And the court said, well, actually, you had ISO procedures in place, which is great. The problem is you didn't follow them. And the court even goes forward, one step further to say, had you followed them, you should have prevented the spill. And the key takeaway here is due diligence needs to be put into practice and regularly revised and updated. Putting it on the shelf from a paper perspective serves you no good. And let's compare and contrast that with a prosecution here in Ontario, and the defendant was named Control Chem. And hopefully on your screen, you're seeing two pictures. The picture on the left shows 3 totes on the right-hand side of the picture. And on the picture on the right, you'll see that the totes are gone. And I'll tell you that the totes were emptied into a local catch basin that you might be able to see in the picture as well. And what occurred was an employee of Control Chem, perhaps thinking the totes were filled with water, it's not entirely clear, discharged these totes into the local catch basin. The problem, of course, was that the totes were not filled with water. The local creek where the catch basin empties was turned milky white. There were a bunch of complaints, alleged adverse effects with the biota, and the company was charged, and it went to trial, and the company said, no, we were duly diligent. And in this case, the court agreed. And the difference here is that the company not only had a certified ISO environmental management plan, not that ISO is necessarily the indicator of due diligence, it just happens to apply here as well, but that the company was extremely diligent and far-sighted, to use the court's language, about implementation. And so some of the key things that Jackie talked about earlier, regular training, documentation, a special design in the building that ensuring that no chemicals were ever near any possible sources of release, like a catch basin. There was a mantra that says nothing leaves the building, and the court agreed, and the defense of due diligence was successful. I'm going to switch gears ever so slightly and talk about sentencing principles. Jackie and I are going to review a handful of cases at a high level to give you a flavor of what types of penalties one might be exposed to in these circumstances. But there are mitigating and aggravating factors that might reduce or increase the penalties sought by the Crown and imposed by the court. And you'll see a handful listed on the slide in front of you. Think about what type of adverse effect may have occurred. Was the action intentional, or was it passive? Was there a financial benefit? Had there been previous warnings or convictions? And what was the post-offense conduct? Is somebody coming to the regulator and saying, I'm sorry, I've made a mistake, or is there an attempt to conceal? And, the fines will depend on all of that, as well as what legislative regime you're in. Is it a federal prosecution, a provincial prosecution, a municipal bylaw prosecution? Is it an individual, a corporation? There might be mandatory minimums, and there might be mandatory maximums if we're into really egregious scenarios. And of course, the seriousness of the impacts. And most of the time, the penalty that is sought is a fine. But in the most egregious of scenarios, in environmental law, we see jail time being sought and awarded by the court, and we'll get into that in a moment.
So the first case to touch on is a recent one out of Ontario, but it's kind of a big deal. Volkswagen, who imported vehicles into Canada that did not meet the required emissions standards, pled guilty to 60 of 100 and some odd charges, if I recall correctly, under the Canadian Environmental Protection Act. So this was a federal prosecution. It happened to take place in Ontario, but it was under the federal legislation. And Volkswagen was fined $196.5 million. That's about 20 times higher than the previously highest fine in Canadian history. And the fine was directed to the Environmental Damages Fund. And the Environmental Damages Fund is where most fines are directed there. And the purpose of the monies are then to help promote projects that deal with restoration, environmental quality improvement, research and development, so that the monies are going back into reinvigorating aspects of the environment. The second case I wanted to touch on is out of Alberta this year, Journey Energy. And there was a leak of 9 cubic meters of crude oil into a nearby creek, and it killed some fish and wildlife. 330 fish, 2 squirrels, 1 toad, 1 vole, and 1 wood frog. So a few animals, fish and mammals suffered. The defendant pled guilty to the offense under APIA and was fined $125,000. In contrast, the Husky case out of Saskatchewan in 2019, there was leaks of crude oil of about 90,000 liters into the North Saskatchewan River, and there was oil was found, and it was found to be deleterious to fish and birds. The fines that were issued were $3,820,000, of which 2.5 was directed for violating the Fisheries Act, 200,000 for violating the Migratory Birds Convention Act. Both of those are federal statutes, and 800,000 for violating the Saskatchewan Environmental Management and Protection Act. And the additional piece, as we mentioned before, was this victim fine surcharge. And in this particular case, it was set at 40%. And the normal course is that money is paid to the court, as opposed to then be filtered through back to victim services, perhaps not victim services in relation to this particular event, but usually victim services as relates to criminal activity where victims otherwise don't receive any amount of compensation. But you can see there's a difference in terms of the types of legislation that's being prosecuted under, and also the monetary amounts of those fines.
I'll quickly review the last couple of cases before we wrap up. And Collingwood Prime is another example in Ontario where we had PCB containing transformers. And interestingly, in this case, the corporate director was initially sentenced to a 45-day intermittent jail term. And there was an appeal, and actually the jail term was revoked, and the fines were lowered a little bit to $150,000 for the corporation and $170,000 for the director personally. And they're still big numbers, but the key here was the moral culpability of this director and whether it merited jail time or not. Syncrude is another example out of Alberta where, Syncrude abandoned a tailings pond and didn't finish remediation. And unfortunately, there were, several great blue herons that were found deceased, and you'll see the numbers that Syncrude was fined a total of $2.75 million, and that was divvied up under EPIA under the Environmental Damages Fund, and a portion was held in trust by AER to fund wildlife and biodiversity projects. And the last case I will quickly mention is Clark Builders, and perhaps it's a little bit more innocuous, but we want to highlight the fact that chlorinated water itself could be a contaminant. And in this case, that's exactly what happened. We had a subcontractor hitting a water main, and 12 million liters of chlorinated water entered the river, and unfortunately caused an adverse effect. And so we have to be careful that, a lot of the cases we've talked about, are oil and gas cases, but there are lots of things that could be considered a contaminant or a pollutant, depending on which piece of legislation you're looking at. So at the beginning of the presentation, Jackie asked you to consider these questions, and hopefully we've provided you a little bit more with which to consider the questions. And I'll look at them again. Is there an environmental management system? Do you have the approvals? Has there been a spill, leak, or discharge? And there are others. But these are the questions that we ask you and your clients to consider so that you're hopefully avoiding and minimizing these environmental risks and liabilities. Hopefully you have taken away that an environmental management system can be the foundation of quite a lot of good actions for you and your clients, and identifying what's reasonable, realistic, implementing those both technically and legally, drafting standard operating procedures, committing resources. The best thing they'll do is hopefully avoid you or your client from ever entering this conversation. But if you are in this conversation, they can also be an indicator of your due diligence. And as you've seen, that's vitally important. From a transactional perspective, I know transactions are way down right now, but you might think about allocating environmental liability, thinking about what do we know and what don't we know, because that can be equally as important. And thinking about whether you're going to contract some of that liability, whether you can contract some of that liability or not. Is there going to be any regulatory liability protection, for example, REMCERT or otherwise involved? And you might consider environmental insurance, which is a whole nother webinar for a different day. Jackie, you want to wrap it up?
Yeah, so to wrap up, we've hit on a number of different topics. Unfortunately, none in all that much depth. They could each be their own sub-webinar, but we have a checklist of things to start you thinking about how to manage environmental liabilities. And the first always is know your environmental risks. Create your team, both technical and legal. You can't start to evaluate what is a risk or a liability if you don't know about it. And that's where understanding those potential liabilities come into play. Are they corporate? Are they individual? Are they regulatory? Are they civil? Those are different aspects that we need to think about in terms of how to take next steps in managing and in creating an appropriate system. Create that appropriate system, and then you have to implement it. As we heard in Zelstoff, it's not good enough for it to sit on the shelf. You actually have to pull it off, dust it off, open it up, and update it, and keep that sort of aspect going. It's really important as well to build the corporate culture. As we heard from Control Chem, their mantra, nothing leaves the building, that was drilled into them. That was what they heard every day. And Control Chem had really incorporated that requirement into their culture. And finally, think about how you may be able to find environmental liability protections, where you can allocate those. Perhaps it is in a transaction, or maybe it's by getting some environmental insurance if that's appropriate. So those are our checklist of ways to think about managing environmental liabilities, and we're happy to take any questions.
Thank you, Jackie and Anand. Very much appreciate that. Thank you, Wilms and Shires. As always, if you have some questions, type them into your chat question box and I will relay them. A reminder for those joining late that the webinars are available online, the recordings later today and the presentation at www.esa.org/webinars. So I have two questions here so far. I'm going to combine them. Can you explain officially induced error? And is there a distinction between advice of a regulator and a decision of a regulator when talking about officially induced error?
Do you want to take that on it?
Yeah, I'm happy to start. So Jackie, at a high level, outlined the requirements. There needs to be a direction of the regulator. I mean, presumably in writing. It could be oral, although that starts to get a little bit tenuous. The regulator has to be acting in its capacity. It's not particularly helpful to get, in Ontario, the Ministry of Natural Resources and Forestry to comment about a contaminated site. You can't rely on that regulator. So it has to be the appropriate regulator. Somebody has to be acting within their capacity and on behalf of the regulator. And they might tell you, yes, it's appropriate for you to build your structure in this location on your property. And if you go ahead and build your structure and the regulator later complains, that is the type of scenario where you have been induced into your error. And let's assume that it was actually offside of a particular piece of legislation. You've been induced into your error by the regulator, and hence that defense arises. The second part of the question is certainly a little bit difficult to answer in the abstract as to what actually constitutes what the regulator needs to tell you. It would be easiest from an evidentiary perspective if there was a letter, even an email. A conversation is a lot harder. Jackie, what do you think?
Perfect. I think you hit it on the head. The key thing, as Anand said, really is about the person has to be, their job has to be administering the particular statute that you're being required to follow. If there's more questions on that, we're happy to take those offline if the person posing the question wants to reach out.
Okay. Any other questions? Give a couple seconds for people to type. Reminder to check out Envirotech for our virtual presentations. Also added a new presentation today for families and kids with Brian Keating, so check that out on our webinar page, and we'll be adding one later today about returning to work and stuff employers should have to or do, checklists, things like that necessary to make sure your workplaces are safe and everything. And now the questions, get some more questions. We've got time for a few more. So when it comes to due diligence defense with an EMS, is there much of a difference between a registered EMS versus a self-declared audited EMS?
I don't think there's necessarily a difference. Certainly when there's a recognized EMS system in place, people know what it is. It's been tested, it has some veracity, but having your own EMS is not necessarily a bar to using it as an element of your defense. Especially, I think you mentioned, Joe, that it's audited. Someone else has had a look at it, made sure that it fits a certain criteria. I think there is merit in having that as well.
Okay, kind of on the same thing as regarding environmental management systems, are certain certifications looked at more favorably in the legal context, like ISO 14000, Forest Care, EMOS, anything like, does that make a difference?
I'm happy to speak to that, Jackie. I think what those certifications do is they pull up the proponent to a minimum level, which is excellent. I don't think much turns on a specific label. Remember, the ultimate trier of fact would be a judge or a justice of the peace. And what people like Jackie and I would be pitching when we're advocating for a due diligence defense would be the substance, not so much just the certification and its label. But I think it helps, and some of the things that those, for example, ISO certifications build in, like external auditing, are fantastic. And so I think that's a good benchmark to work towards. What do you think, Jackie?
Yep, agreed.
Okay, gonna do three more. Someone says recall a case back in 2016 in Edmonton where the operator of a dry cleaning facility was convicted of mishandling PERC under the federal regulations and was sentenced to jail time, which I think was commuted to house arrest. Do you see sentences like this is an increasing trend?
So since that time, I know that case. We have seen Collingwood Prime was another case where originally before the appeal, where jail time was part of the assessment. In that case, the sentencing judge relied on a case called Sinclair, which was also about PCBs, but had a very moral, blameworthy element to it. So where the triers of fact are hearing this information and where there's intentional actions or either actions or inactions, it could be, those are the types of situations where the court is going to consider whether a jail term is appropriate. They're very egregious situations, but we are seeing them. And prior to the Alberta dry cleaner situation, it was rare. I'm not even sure if I know of any, but it certainly was very rare prior to that. And now we've seen 2 or 3 more cases where jail time was found to be the appropriate response. So, you know, if you're doing really bad stuff, then the court's going to look at that and is going to consider how to best punish, because that's what prosecutions are about, is punishing for the offenses that were done.
Makes sense. Okay, I'm going to combine 2 more here. Dealing with emerging contaminants like PFAS. Has there been cases in Canada with respect to PFAS liability charges? And what environmental liabilities exist when it comes to the emerging contaminants?
I don't know of any in relation to PFAS specifically, or PFOA on it. Have you heard of any?
No, we certainly talk about it a lot, especially when Jackie and I attend technical seminars like this, and there are technical presenters, but we've not seen it yet in the civil or regulatory liability sphere. That's not to say it's not coming.
Part of the issue too is the contaminant levels, and you know, the PFAS is as I understand, is basically everywhere and in almost everything, including us. So I think that's as you said, as the question raised was, is the emerging contaminant, and we haven't seen anything yet that I'm aware of.
Okay, and then the last one revolves around foreign ownership. If the majority of officers and directors of a company reside outside of Canada, do Canadian regulators have any means to go after those responsible who live outside of Canada?
Short answer is yes. The long answer is it's complicated.
Very complicated.
So the case I mentioned, Baker. Some of those former directors and officers were not residents of Canada. And you get into a question about attornment to jurisdiction. That is, do any entities or individuals outside of Canada attorn to Canadian jurisdiction? And if they don't, they might give up their right to participate in the regulatory proceeding in Canada, but then the regulator has to go take that judgment or that order into the foreign jurisdiction and try to enforce it. And that's very difficult to do, and we have not seen regulators do that with any regularity at all.
And there are some jurisdictions that have reciprocal enforcement order legislation that may make it easier, but it's still a fairly onerous process.
Okay, well, thank you both for doing this today. Really appreciate it. Thank you to everyone who attended. Thank you to today's webinar sponsor, Trace Associates. And thank you to Site for continuing to power our webinar series and make them free for everyone. And my last plug for Envirotech and the remaining webinars, please check them out. Please register. Please support ESA. We greatly appreciate it. Thank you today for attending, and stay safe. Take care.
Thank you, Joe. Thanks all.
Thanks very much, Joe. Take care.
Take care.